Hello and welcome to a fresh episode of Legal Wrangle on corporate laws. Now let's begin to dive into the details of today's cases. But before that, today's headlines. Apex Court explains if transfer of arbitral hearings from one jurisdiction to other amounts to dismissal of an application to set aside an arbitral award. Supreme Court holds principle of equality between creditors as flawed in Essar Steel Insolvency case. Why was Mr Chidambaram granted bail after 105 days of judicial custody in INX Media case? The Apex Court explains.
The dispute arose from a contract to construct a 2000 megawatt hydropower project which was awarded by NHPC to the Hyderabad-based construction company named Soma Enterprise. In the dispute about payment of dues, NHPC challenged the domestic arbitral award amounting to Rs 424 crores which was issued against it. The arbitration clause was framed to include both Delhi and Faridabad as the venue of the arbitration. During the pendency of Section 34 petition, which was filed before District Judge at Faridabad, Mr Soma moved an application to transfer the hearings from Faridabad to Delhi before the Commercial Court, Gurugram. After the transfer was allowed, NHPC moved the High Court under the pretext that transfer order amounted to refusal to set aside the arbitral award under Section 34. The High Court allowed the appeal and reasoned that Delhi was only a convenient venue where arbitral proceedings were held, and Faridabad being the place where cause of action arose, the jurisdiction fell upon the Faridabad courts.
Speaking on the issue of maintainability of appeal, the Supreme Court rejected the reasoning of the High Court. Agreeing with the senior advocate, Dr. Abhishek Singhvi, the court accepted the contention that an order which allows an application invoking the inherent powers of the courts will not in any way amount to an order refusing to set aside an arbitral award under 34 of the Arbitration Act. Therefore, if the order itself was not qualified under one of the clauses of Section 34, any other order which does not lead to the rejection of Section 34 petition cannot be clothed as the order against which an appeal is maintainable under 37. Thus, a transfer order cannot become an order which refuses to hear a Section 34 application.
Also, speaking on the issue of jurisdiction of Faridabad courts, Presiding Justice Rohinton Nariman made it clear that if parties to the arbitration has chosen the Delhi court to have exclusive jurisdiction, merely because part of cause of action arose at Faridabad, the courts of Haryana will not be conferred with the exclusive jurisdiction to entertain a petition to set aside the arbitral award. Reciting the settled law, the Apex Court made it clear that once the seat of arbitration has been chosen, the clause in the agreement determining the seat of arbitration will convert into an exclusive jurisdiction clause. Thus, the transfer order was restored and the appeal of Mr Soma was allowed. Moving on, our next case highlights the impact of Essar Steel judgment in the realm of insolvency.
In the matter of insolvency of Essar Steel, when the bid of ArcelorMittal was approved by majority members of the Committee of Creditors, the NCLAT held that there can be no difference between a financial creditor and an operational creditor or in the matter of payment of dues. Then the Appellate Tribunal laid down the groundwork for non-discrimination between various creditors of the insolvent. It held that the profits generated by the corporate debtor during the insolvency resolution process will be equally distributed amongst the financial creditors and the operational creditors. But the most important direction it gave was the Committee of Creditors was not empowered under the IBC to decide the manner in which the distribution is to be made between one or other creditors. The decision of the NCLAT was passed in July 4, 2019, which created roadblocks for ArcelorMittal to overtake the business of Essar Steel.
Setting aside the NCLAT theory, the larger bench of the Apex Court decided that three things are clear under the IBC legislation. First, principle of equality in matter of distribution of assets of the corporate insolvent is completely flawed. The equitable treatment of creditor is equitable treatment only within the same class and not when the creditors are positioned differently. Second, rights of distribution of claims are with the committee of creditors and not with the tribunal. The NCLT or NCLAT cannot interfere with the commercial wisdom of the committee. It is the commercial wisdom of the committee to negotiate and accept a resolution plan, which may involve differential payment to different classes of creditors. The most the tribunal can do is to send the resolution plan back for reconsideration, but it cannot change the plan and decide what percentage is to be given to which type of creditor. And third, the committees can appoint subcommittees. The court accepted that even though the administrative nature of the committee cannot be delegated, this does not mean that subcommittees cannot be appointed for the purpose of negotiating with resolution applicants. As long as the actions of the subcommittees are authorized by the COC, its decisions cannot be challenged.
The court also provided some relaxation in following the strict period of 330 days for completion of resolution process by saying that it is not mandatory and under exceptional cases, the tribunal can extend the appointed time. Earlier in the IBC allowed 270 days as maximum period to achieve resolution, which was increased to 330 days by an amendment. Thus, in the manner the Supreme Court paved the way for insolvency and resolution process of the Essar Steel, which will now take place in accordance with resolution plan of ArcelorMittal. Next, it was the position of the High Courts that wherever there is a case of economic offences, regular bail or anticipatory bail cannot be granted even if criteria for grant of bail stands satisfied. The larger bench of the Apex Court has now changed the position by granting bail to our former Finance Minister, Mr. P. Chidambaram, in INX Media case.
In the course of multiple bail hearings, the Delhi High Court first rejected the anticipatory bail application of Mr. Chidambaram and then rejected his regular bail application. The SLP filed against the denial of anticipatory bail was dismissed on September this year. Thus, the only issue remained was denial of regular bail application. Speaking for the former minister, Mr. Kapil Sibal argued the dismissal of two primary grounds. First, that the grant of regular bail cannot be denied after the triple test was already found in favor of the appellant. Second, the bail cannot be denied on the basis of gravity of offence.
While addressing the appeal, the larger bench of Supreme Court expressed its disapproval, in which the High Court recorded its findings about the alleged offence of economic crime. The bench made it clear that while considering a bail application, the courts are barred from recording a finding from the sealed materials furnished by the prosecution, which still needs to be perused during the course of the trial. It is held even if the allegation is one of the grave economic offence, it is not a rule that bail should be denied in every case, since there is no such bar in the legislature yet. Irrespective of the nature and gravity of charge, the precedent of another case alone will not be the basis for either grant or refusal of the bail, though it may have a bearing on the principle. Even though triple test was satisfied in the case and the High Court was satisfied in referring to the gravity of offence, but taking into the additional factor of custodial duration, the application was entitled to bail. Thus, it was established that gravity of offence cannot become an absolute bar in granting bail in economic offence cases where the test was found satisfied in applicant's favour. That's it for today's episode on corporate laws. If you want more of cases on Companies Act, capital market laws, competition laws, IPR, PMLA, FEMA and other cases, please log on to www.tiolcorplaws.com. Thank you for watching.